at fault than they really are. There is also in this state a doctrine coming into play called comparative negligence, which is somewhat complicated, but I want to point that out to you because the degree of fault which might be attributable to each party is important. So while you may feel like you share some of the blame, the percentage of blame for causing the accident is very important. So it's vitally important as to whether or not you are 20% to blame, for instance, or perhaps 80%. So don't, at that time and place, try to get into assessing the degree of your own fault for the accident. You're probably not going to be in the emotional shape to do that very coolly anyway. And if you do it, it can and probably will be used against you at some time. Try to also obtain the names and addresses, phone numbers of any witnesses to the accident. This information should be on the accident report that the police will file after they investigate the incident. But some witnesses may not stay around for the police to complete their report or even to arrive at the scene. So any of this type of information which you can obtain on your own may prove to be very helpful to you. I might also add, try to remember to make sure you know which police agency is doing the investigation of the accident. I've had it occur a number of times. People have come to see me regarding an accident and they don't remember or did not pay attention as to what police agency did the investigation and report. A county police agency, city police, state police, what have you. Makes it a lot easier and cuts through a lot of time-consuming efforts if you know that from the beginning. If you feel you're injured, however slight, certainly see a doctor. It seems obvious to say, if you think you are injured to any degree, you should see a professional, and that professional being a physician. You know, of course, that some serious injuries do not always manifest themselves right away, and for that reason you need to see a doctor who can ascertain whether or not that is something like that is possible or probable. And bear in mind, if you do not see a doctor, some injury does surface in the future, 30 days down the line or 60 days down the line. It might be difficult for you to convince anyone that this injury was a result of this particular accident if there's no record that you saw a doctor immediately after the accident. Let me say that you are likely to face some degree of skepticism on that point if there is no record to show that you felt yourself injured to any degree right after the accident. So seeing a doctor immediately can be very important. It is also essential that you contact your insurance company immediately. Advise them of the accident, regardless of whose fault you think it is. Most companies, in fact, I would venture to say all insurance companies require any accident that you are involved in to be reported to them if you expect them to play any part in compensating you or others as a result of it. And usually the time limit is 30 days. If you fail to do this, you could well jeopardize your insurance coverage. You may find that the insurance company is no longer obligated to represent you in this matter if you have not notified them in a timely fashion. And lastly, if you have questions about your rights or your duties or what to expect from your insurance company or that of the other party or parties, contact an attorney. That's what we're here for, and I think you'll find that in the vast majority of cases There will be no charge for initial consultation on these type of matters. At this point, I think I will turn it over to Mr. Crawford, who will, as I said, talk about what you should do if you have sustained injury or damage as a result of a car accident, and especially what you can expect from your own insurance company. Jim?
Thank you. Accident in the state of Kentucky, regardless of whether you're at fault or the other person is at fault, generally speaking, you will have what's referred to as no-fault benefits or PIP benefits to cover you. Now, that's not always the case, but for most people in the state of Kentucky, that is the situation. Most of us have basic insurance coverage of $25,000 per person or $50,000 per accident and $10,000 in property damage. And in addition to that basic coverage, we have what's referred to as no-fault coverage or PIP coverage. Some of us, a few of us, have rejected the rights to sue in the state of Kentucky and don't have no-fault or PIP coverage. But most people have no-fault or PIP coverage. What that means is, as I've indicated, regardless of who caused the accident, you can collect the cost of your medical bills, including doctor's bills, hospital bills, prescriptions, drug bills, rehabilitation bills that you incur in the accident up to a maximum of $10,000. You can also recover lost wages that you incur as a result of the accident. Now, the lost wages that you can recover per week has a cap of $200. In other words, if you're off work for a period of 4 weeks, and if you earn more than $200 per week at your place of employment, you can collect $200 per week for those 4 weeks that you are off, or $800. The maximum amount of no-fault benefits that you can recover out of an accident in the normal situation is $10,000. Most of us have no-fault coverage or PIP coverage that is capped out at $10,000. In other words, the medical bills that we incur, hospital bills that we incur, and lost wages, the most we can recover is up to $10,000. Now, you can, and some people have this, have purchased more than the $10,000 in PIP or no-fault benefits. In order to have that on your policy, and you specifically need to talk to your company about that, should you be involved in an accident. If you have more than the $10,000, you have bought and paid for that. Now, if a person is killed in a car wreck, there are additional benefits beyond medical bills and lost wages that can be recovered. But once again, the cap or the maximum amount that can be recovered is $10,000. $1,000 in death benefits will be paid to the estate of the deceased person, and the survivors or the heirs of the deceased individual can collect what we refer to as survivors replacement services loss and survivors economic loss. Simply stated, this means that to the extent that the person that was killed was providing certain services to the family or the heirs, they can recover up to $200 per week, up to a maximum of $9,000, because the $1,000 has already been paid in the form of a death benefit for those lost services or those economic losses that have resulted due to the person's death. So that is